Welcome back. Former President Jacob Zuma has lost his bid to stay an arrest order. The Pietermaritzburg High Court dismissed his application this morning. The former president brought the application before the court on Tuesday, arguing that his arrest should be stayed until the Constitutional Court hears his rescission application next Monday. The court has sentenced him to 15 months behind bars for being in contempt of court after he failed to appear before the state capture inquiry. Meanwhile, it's being reported that Zuma's lawyers are readying for fresh or consequential ConCourt action if High Court case goes his way. The rescission application is set down for Monday. So let's speak now to legal analyst, Advocate Craig Watt-Pringle, to talk about this. A very good evening to you, and thank you so much for speaking to us.
Good evening.
So were you expecting this verdict or not?
I was expecting the outcome that we've heard from the Pietermaritzburg High Court, yes.
Mm-hmm. So let's talk about the verdict that was given by the Judge Nguni. Let's talk a little bit more about it. Counsel for Zuma told the Pietermaritzburg High Court that it had jurisdiction on 3 different grounds to stay the Constitutional Court for his arrest pending his application to rescind his 15-month sentence for contempt. Let's juxtapose that against what Judge Nguni's verdict said today.
Yes, I have not had the opportunity to read that judgment, so I can't really comment on the reasoning of the learned judge. All I can say is that it was always going to be a difficult ask to persuade the High Court to, in effect, stay the implementation of the Constitutional Court's order. It should also be said that people being arrested and held in incarceration pending bail applications and the like are part and parcel of our criminal procedure. So generally, you know, being temporarily incarcerated pending some kind of a legal process is not inevitably considered to amount to irreparable harm. And irreparable harm is one of the requirements of this type of relief. But I think fundamentally the debate revolved around the jurisdiction of a lower court, in effect, to stay the operation of the highest court in the land.
All right, just so in your legal opinion, what can we expect now going forward? And I know you said you haven't read the judgment, but just on the surface, do you think that it will be precedent setting, that we no longer have to find ourselves in a position where legal minds argue against what has been set to be pretty much the doctrine or the principle?
Well, I think that this was an extremely unique case. So to what extent it's precedent setting, I don't know. Obviously, if the same situation were to arise in a high court, then this would constitute a precedent. But it is a very unusual case that the High Court is asked to stay the operation of a constitutional court order.
So I'd like to just get your views on Judge Nguni dismissing the application with costs, and such costs, he said, should include that of senior counsel. Is this commonplace for a judge to highlight the fact that the cost will also include that of senior counsel?
No, that's just for guidance of the taxing master. It's only where a court feels that that the employment of senior counsel was not justified that the court might then exclude the costs of senior counsel. So that's not a big issue. Okay. That's a fairly normal.
All right. Thank you so much for speaking to us, legal analyst, Advocate Craig Watt-Pringle.